Hi, everyone. So I'm going to discuss the elements of negligence and some negligence defenses as well. I want to help you to understand the basic concepts so that it'll be easy for you when you see a question on your exam. So if you've listened to some of my lectures on YouTube, then you may notice that my voice is a little crackly. So I am losing my voice, but I think I can get this done for you before it starts going. So just bear with me here. Okay, so the elements of negligence. Negligence is a failure to act as a reasonable person would in the same circumstance. There are some elements of negligence that might need to be addressed when you're taking your insurance exam. And I'm going to talk to you about the elements that need to be present in order to determine negligence. So understand that negligence is a tort law. So negligence is a tort law, and tort lawyers or lawyers who handle negligence lawsuits are considered tort lawyers. This is an area of law where someone would sue another for a wrongful act that causes a person to suffer a loss or harm, resulting in a legal liability for the person who commits the act. So if someone was rear-ended and sued the party who hit them, this would not be considered a criminal act. It would be considered a negligent tort. And in order to prove negligence, there has to be certain elements involved. And essentially, it's up to the party bringing the lawsuit to provide the proof that a person was negligent for that act. So negligence has to be proven. The injured party has to be able to prove that the other party violated a legal duty. There has to be a direct result of the defendant's negligent act, and there has to be an actual loss or damage. The proximate cause, the initial cause, would lead to a chain of events that cause a loss or damage. So the proximate cause is an event that is related to the injury that's essentially the cause of the injury. If you weren't driving so fast near the intersection, you would have been able to stop in time to avoid from hitting my bumper. The proximate cause was that you were driving too fast, and that led to a series of events that caused you to rear end me, and I suffered a loss. Now, as a negligence defense, there is something called an intervening cause. This is the cause that actually led to the loss, and so the party being sued can try to prove their innocence. Yes, I did rear end you, but it was only because when you cut me off and slammed on your brakes, I didn't have enough time to respond. That is why I only hit the left side of your bumper, almost like a side swipe. So this is actually a good case, giving the judge something to think about. All the elements are there that prove negligence, but the intervening cause might also indicate otherwise. So here's a scenario. So you leave your violent dog in your front yard, outside, untied. Your dog ends up biting a couple of kids passing by. Who is the negligent party? The dog or the kids? So if we can prove that the proximate cause of the owner leaving the dog outside untied led to a chain of events that led to the dog biting the kids and suffering an injury or loss, then we can prove that the owner was negligent. So we could say that the proximate cause was the failure to tie your dog up. Now, if there was an intervening cause, it's possible that your act would not be considered the proximate cause and you might not be eligible, you might not be negligent. The owner can argue that the kids intervened since they were teasing and provoking the dog. This intervening cause could possibly prove the owner not negligent. Now, let me just tell you, I'm not a lawyer. I am an insurance professional. So this is not law school 101. I'm really not sure who would win in this case. And essentially, I would imagine that that's up to the judge. I'm merely attempting to help you to understand the elements of negligence so that you can answer the simple questions that will get you to pass your insurance exam. So that's my disclaimer. A lot of times I'll get people saying, digging a little bit deeper into it, but it's just so you can learn the elements of negligence. So there's also there's defenses of negligence. So we did talk about the intervening cause, which is one of them, the interference involving a proximate cause. There's also one called assumption of the risk. This is when you agree to take a risk of engaging in certain activities. You cannot sue if you are injured during the course of those activities. So for example, bungee jumping, let's say the cord breaks or you injure yourself while you're bungee jumping, you that might be considered an assumption of the risk. There is a high risk when you're doing that, so you cannot sue if something happens, if is a loss. So that's it for negligence elements. I do want to thank you guys for checking out my videos. I made over 1,000 subscribers so far, so thank you guys for that. Please subscribe for updated videos, and if you like, let me know. Check out my webpage, which I have linked here as well, so if you can see that right there. And then if you have any questions, send me an email. Feel free to do that, and I try to update or get into my emails um, daily. So feel free to do that. Thank you again. My name is Rebecca, and I am your insurance lady.